Afternoon, sir. Could I have your name, please?
Jonathan James Winter.
All right, Mr. Winter, my name is Judge Hesslink. I'll be arraigning you this afternoon. That involves me reading the charges to you, then telling you what your rights are, and then addressing bond. I have with me on Zoom Mr. Brown as a defense attorney and Mr. Fortier from the prosecutor's office. The charge in the complaint against you reads as follows. It says that on or about July the 10th of 2025 in Bagley Township of Otsego County, that you did commit the following two offenses. Count one is entitled breaking and entering a vehicle to steal property between $200 and $1,000. It says that you did enter or break into a Chevy Equinox, a motor vehicle, to steal or unlawfully remove property therefrom of a value of $200 or more, but less than $1,000, contrary to Michigan compiled law. That is a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000 fine, or 3 times the value of the property stolen, whichever is greater. Do you understand the name of count one?
It's a misdemeanor count, correct?
That's correct. Do you understand the name of it to be breaking and entering a vehicle to steal property between $200 and $1,000?
Okay.
I just need to know if you understand that, sir. Not asking if you agree with it.
Yes, I understand.
All right. And you understand the misdemeanor maximum penalty is 1 year and or $2,000 and up to 3 times the value of the property, whichever is greater?
Yep.
All right. Count two reads as follows. It says that on the same date, time, and place that you did commit the offense of breaking and entering a vehicle to steal property less than $200. And that says that you did enter or break into a Ford F-150, a motor vehicle, to steal property or unlawfully remove property therefrom of a value less than $200. That also is a misdemeanor offense, but it has a maximum penalty of 93 days and or $500, or 3 times the value of the property stolen, whichever is greater. You understand the name of count two?
Yes.
You understand the maximum penalty for count two?
Yes.
All right. Right now, you have certain rights as to those charges, and I want to make sure that you understand them so that you can make an informed decision in the future. You have the right to plead guilty, not guilty, or no contest. You have the right to an attorney to represent you, and you have the right to have a trial by a judge or by a jury. Mr. Brown is here to assist us with the attorney, and we'll talk about that in just a minute. If you wish to have a trial in the future, you also have the following trial rights: to see, hear, and question all the witnesses against you, to present witnesses and evidence for your defense, and to get an order from the court called a subpoena to require those witnesses to appear and testify. At trial, you could also testify, or you could choose to remain silent. And if you chose to remain silent, that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof be on the prosecutor at all times. Finally, you'd also have the right to appeal automatically any error that happened at trial. However, if you enter a plea in the future, you may be limited to asking the court for permission to appeal. Do you understand all of those trial rights?
Yes.
Do you have any questions about any of those trial rights?
No.
All right. Mr. Brown, have you had a chance to speak to Mr. Winter about his right to an attorney?
Yes, Your Honor. He would qualify, and that information has been sent to Mr. Keel's office.
Welcome back to another intense courtroom breakdown. Today we're following Jonathan James W.R., who finds himself in a legal tangle that's equal parts confusing and alarming. Standing before Judge Hesslink, he's charged with not 1, but 2 counts of breaking and entering into vehicles. One over $200, one under. Both misdemeanors, yes. But the story doesn't end there. Jonathan isn't just some first-time offender. He's out on parole for prior home invasions, and his criminal history stretches over a decade. Over the next few minutes, you'll see the clash between defense, prosecution, and a judge carefully weighing community risk versus legal procedure. Buckle up. It's a wild ride, and by the end, you'll want to decide for yourself if justice was served or if chaos reigns.
What we're going to do, so I'll get the paperwork and get it to Mr. Gilo's office, and he'll get that information to you, and then the attorney will contact you subsequently. All right, now that we've set those things, I will address bond. So what I'm going to do is I'm going to hear from each of the attorneys as to bond, and then, sir, I'm going to listen to what you have to say, if anything, about bond as well. So, Mr. Fortier, your thoughts.
Your Honor, I did submit a bond recommendation form. In there, I did request a $5,000 cash or surety bond. That's largely, I mean, it's a larger amount considering what he's charged with, in the fact that they're both misdemeanors. However, I'm requesting that amount partially based on the fact that these were two thefts within motor vehicles that were part of a string of essentially vehicle burglaries. And on top of that, his criminal history is quite extensive. It is listed in that recommendation form. He's out on parole for a home invasion second degree. So he's got a history of stealing other people's property. That wasn't even his first home invasion. He had another one back in 2008. So like I said, he's on parole for that. He does have a parole hold. I confirmed that with Agent Doug DeLeo with the Department of Corrections. So there is an administrative warrant that's holding him. So regardless of what the court sets the bond amount at, he's not going anywhere, essentially. So in addition to the amount requested, we are seeking that there be the standard conditions of bond, along with no drugs or alcohol, no illicit controlled substances, and then to not have any contact with Timony Bonifant or Mallory Bonifant. They are the two vehicle owners that are in this case, and then also not to return to the property of 19 Grove Avenue here in Gaylord. That's the property where the theft occurred.
All right, Mr. Brown.
Thank you, Your Honor. Mr. Winter is a lifelong resident of this county. He has ties to this community. I don't think he's going to go anywhere. Failure to appear is not really going to be an issue. It is my understanding he did, or possibly was arraigned yesterday on an FOC warrant. So I don't know if there's a significant bond in that matter as well. But as Mr. Fortier mentioned, he is on a parole hold. So bond is really not a huge issue, as he's not going to be able to bond out no matter what it is set at. But I would ask the court just to consider.
Here, the judge is meticulously walking Jonathan through his charges and trial rights, which is standard procedure but essential for understanding his options. Count 1, breaking and entering a Chevy Equinox, could mean up to a year in jail or $2,000 in fines. Count 2, a Ford F-150, carries a lighter sentence. But notice Jonathan's reactions, polite, almost robotic. He answers correctly, but there's a subtle confusion. The defense attorney confirms he qualifies for court-appointed counsel, ensuring Jonathan won't be navigating this maze alone. Meanwhile, the prosecutor already starts painting a broader picture. Jonathan isn't just facing misdemeanors. He's part of a larger pattern. This VO helps viewers grasp why understanding these rights is more than a formality. It's a critical checkpoint before decisions are made that could affect his future.
To do that, and if he wishes in the future, he can readdress that issue, and I'll consider it at that point. I would confirm, because Mr. Brown brought it up, there was a friend of the court hearing, I believe, either yesterday or the day before. My memory is that there was a bond set in the amount of $4,900 that he could be released upon payment of that. I do not know whether that has occurred yet or not. So I
have not been able to do that, Your Honor. I'm not going to be able to do that.
All right. I appreciate that, Mr. Winter. Thank you. All right. In setting a bond, I am required to look at whether or not the person will appear as required, and then if there's any danger to the community. The prosecutor brings up history, and which is quite extensive, including resisting and obstructing convictions twice in 2004, larceny in a building in 2004, home invasion in third in 2008, prisoner in possession of weapons in 2013, and then a second home invasion, this time a home invasion second in 2019. Also, what the prosecutor alleges is a string of vehicle burglaries, of which this may have been a part. So for those reasons, I would need to believe that Mr. Winter might be a danger to the community. However, these are simply misdemeanor matters. And there, I do believe that $5,000 cash assurity is a little high on that end, given the fact that he has a parole hold and also an FOC warrant with extensive, a relatively large dollar amount on it. It's unlikely he's going to be able to post bond, so therefore I'm not going to set the bond in this matter quite so high. I will set it at, because of his prior histories, I'm not going to give him a 10% bond, so I will set it simply at $500.
Now we're entering the bond discussion, and this is where the courtroom drama intensifies. The prosecutor requests a $5,000 bond due to Jonathan's extensive criminal history, including home invasions, thefts, and being on parole. But here's the twist. The defense argues bond is essentially irrelevant. Jonathan can't leave jail anyway because of parole holds. This is a classic courtroom tug-of-war. On one side, a history of offenses implying risk. On the other, procedural technicalities limiting immediate consequences. The judge is careful, weighing both sides, considering mental health concerns, and ensuring medications are provided. Viewers, take note. Bond isn't just about freedom. It's about public safety, prior behavior, and legal strategy. What would you decide if you were in the judge's seat?
That you did commit the following 2 offenses. Count 1 is named breaking and entering a building with intent. It reads that you did break and enter a storage shed located at 619 West Mitchell Street with the intent to commit the crime of larceny therein, contrary to the Michigan compiled laws. That is a felony offense. It has a maximum penalty of 10 years. You understand the name of that offense?
No.
What don't you understand about it?
What's the date of that offense?
The name of that offense.
Oh, I'm sorry, Your Honor. Yes, I understand.
All right. Do you understand the maximum penalty of that offense?
Yeah.
All right. Count 2 alleges stolen property, receiving and concealing over $200 but less than $1,000. It reads as follows. It says that on that same date, time, and place, July 7th of 2025 in the city of Gaylord, Otsego County, that you did commit the offense of receiving and concealing stolen property over $200 but less than $1,000 by buying, receiving, possessing, concealing, or aiding in the concealing of an e-bike, stolen, embezzled, or converted property, knowing that it was, or having reason to know that it was the property was stolen, embezzled, or converted, and the value was between $200 and $1,000. That is a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000 or 3 times the value of the property, whichever is greater. You understand the name of count 2?
Yes.
You understand the maximum possible penalty of count?
Here's where the judge's meticulous approach shines. Even though today's charges are misdemeanors, Jonathan's history cannot be ignored. From resisting arrest to larceny to multiple home invasions, the record tells a story. This VO emphasizes the balancing act. The judge must weigh public safety against procedural fairness. The bond set $500 cash is deliberately lower than the prosecutor requested, reflecting an understanding that Jonathan is unlikely to post bond due to parole restrictions and existing warrants. This moment is a textbook example of how prior criminal behavior informs judicial discretion and why context is everything.
Count 2 starts out as a misdemeanor. It's alleged to be a second or subsequent offense by saying that appearing that on June 14th of 2012, you were previously convicted of attempting to commit, receiving and concealing stolen property, $200 or more, but less than $1,000 in the 87A District Court. And therefore, this is alleged to be a second or subsequent offense. And because it is a second or subsequent offense, it is now a felony offense, which has a maximum penalty of 5 years and or a $10,000 fine or 3 times the value of the property, whichever is greater. Do you understand now that count 2 has been raised to a felony level offense?
Yes.
All right. Now, as to both count 1, which is a 10-year felony, and count 2, which is now has a subsequent offense notice, which raises it to a 5-year felony, there is also a habitual offender notice, habitual offender 4th offense notice, which also has the impact of raising the penalty. So I want you to listen carefully to this as well. It says that you are previously convicted of 3 or more felonies or attempts to commit felonies, in that on or about July 29th of 2019, you were convicted of the offense of home invasion second degree in violation of the Michigan compiled laws in the 46th Circuit Court for Otsego County in the state of Michigan. On or about April 4th of 2017, you were convicted of the offense of prisoner possessing contraband in violation of the Michigan compiled laws in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about May 7th of 2013, you were convicted of the offense of prisoner possessing weapons in violation of the Michigan compiled laws in the 46th Circuit Court for the County of Otsego in the state of Michigan. Now, because these two, count 1 and count 2, both have a penalty of 5 years or more, the fourth habitual offender notice makes each of those a potential life felony offense. You understand the new maximum penalty on both count 1 and count 2 is now life imprisonment?
Unfortunately, yes.
Pay attention to Jonathan here. His behavior is telling. Sometimes quiet and compliant, sometimes blurting out confused statements. This oscillation can influence how a judge perceives credibility, composure, and mental state. Defense highlights mental health concerns, questioning whether he receives necessary medication while in custody. The prosecution emphasizes risk and pattern of offenses. This VO is key for viewers to understand that courtrooms aren't just about legal text. They're about human behavior, perception, and courtroom presence. Small reactions and pauses can speak.
Called a subpoena, requiring those witnesses to appear and testify. You could testify, or you could remain silent, and if you chose to remain silent, that silence could not be used against you. You would also have at trial the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden remain with the prosecutor at all times. Finally, at trial, you'd have the right to automatically appeal any error. However, if in the future you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. You understand all of those rights that I've just given you?
Yes.
You have any questions about any of those rights?
That's why I talked to my attorney, Your Honor.
All right, that's a good idea. Mr. Brown, have you had an opportunity to discuss counsel with Mr. Wenner?
I have, Your Honor. He will qualify. That information has been sent to Mr. Gilo's office. I currently represent him on another case. It is more than likely I'm going to be appointed to this one as well.
All right. So, Mr. Wenner, what I'm going to do is I'm going to appoint court-appointed counsel for you, or approve court-appointed counsel for you. That information is going to be sent to the administrator who deals with court-appointed attorneys, who will appoint a specific attorney for you. That may be Mr. Brown because you already have a relationship with him. But in the meantime, until you have a chance to speak with that lawyer, I'm going to enter a not guilty plea on your behalf in order to preserve your rights. I'm also going to set a couple of quick court hearings to help preserve your rights. The first will be set within 7 days. That's called a probable cause conference. That's a chance for the prosecutor and the defense attorney to discuss the case and see if there's a way to resolve it quickly. I'm also going to set a preliminary examination within the next 21 days. That's a hearing in district court before me as the judge to find out if there's a small amount of evidence called probable cause to believe that you've committed the crimes that you've been charged with. It is not a determination of guilt or innocence. It simply is a check to make sure that there's sufficient evidence to proceed. Do you have any questions about those two hearings that we just talked about?
No, Your Honor, but I really need to have my attorney come here and talk to me way before any court date I have, because I have to talk to him about things that he needs to do for me that are very important and they are absolutely.
Now Jonathan faces additional felony level scrutiny with a building break-in and receiving stolen property charges. Notice the judge carefully clarifying each offense and maximum penalties. The details are dense. Dates, locations, property values, all critical for legal accuracy. For viewers, this illustrates a larger pattern. Jonathan's cases aren't isolated incidents. They show a repeated cycle of property-related crimes. Even when values are relatively low, cumulative behavior paints a risk profile. This VO helps viewers connect dots between seemingly small misdemeanors and larger criminal trajectories, showing how prior offenses compound legal
with the Department of Corrections. So he's not going anywhere on the parole violation. So I would just ask the court to just set a bond amount, knowing that he's not going to go anywhere. And then in the event that somehow he is able to bond out, just having the standard conditions of bond put in place, and that there be no consumption of any alcohol or illicit controlled substances, no bars, random testing, to report via community corrections, and that he not have contact with the victim in the case, which is his name is Jason Vanderlaan, and not to return to the address listed in count 1.
All right. Mr. Brown?
Your Honor, everything Mr. Ford here says is correct. I was with him when he was arraigned, I think last week, on a misdemeanor. Court issued a $500 cash or surety bond, and he was in the exact same position. As far as his parole detainer, he hasn't posted that bond either. So whatever the bond amount is, he is very, very unlikely to be taken off that detainer in time to post it. So I would ask court to consider that when setting a bond in this particular matter as well.
All right, thank you. Mr. Winter, I simply want to caution you before you make any statements that anything that you say right now is being recorded, so it could be used against you later. So I don't want you to make any statements about the facts of this underlying case. But if you have information for me that would relate to bond, I'd be happy to listen to that. And this is your opportunity, sir.
Your Honor, I have no further information than what they have already.
Here's the kicker. The judge sets bond at $500, significantly lower than expected. But it's almost irrelevant. Jonathan already faces nearly $5,000 in hold from prior cases, likely child support or other warrants. The real-world impact? He's not going anywhere anytime soon. For viewers, this is a perfect example of how procedural nuances, overlapping cases, and prior history combine to determine outcomes more than the charges themselves. It also highlights how strategic legal representation is essential in navigating these overlapping legal layers.
2005, it's like a non-sufficient funds check. Number of misdemeanors in 2007, 2008, 2009, he was convicted of home invasion, 3rd degree. 2011, a misdemeanor for drugs. 2012, misdemeanor stolen or receiving and concealing stolen property between 200 and 1,000. 2013, or marijuana drug offense misdemeanors. 2013 in 46th Circuit Court, drug felony, second offense notice. 2013 46th Circuit Court, prisoner in possession of weapons. 2017 jail contraband in 46th Circuit Court. 2019 home invasion, 2nd degree. And we have a bunch of files, I believe, if memory serves, pending within district court now against Mr. Winter. Based on the serious nature of the charges with the habitual 4th offender notice and his criminal history, I'm going to set bond at $5,000 cash or surety, no 10%. His actions with the police and his dangerousness, as shown by his criminal history, don't warrant a 10% bond. If he is able to post bond, he must personally appear for any scheduled court date. He must abide by any judgment of the court, may not leave the state of Michigan without permission of the court, may not commit any crime while released, must immediately notify the court in writing of any change of address or telephone number, may not use alcohol or illegal controlled substances while on bond, must participate in a substance abuse testing or monitoring program through community corrections, may not possess or purchase a firearm or other dangerous weapon, may not have any contact, direct or indirect, with Jason Vanderlaan, Direct or indirect means by third parties, by computer, by internet, social media, or any other way. You may not have any contact whatsoever with Jason Vanderlaan. You also may not enter the following premises or area: 619 West Mitchell Street in Gaylord, Michigan. And you must contact upon your release from jail within 24 hours of Community Corrections, which is the agency that monitors the persons that are on felony bail for the court. And that phone number will be provided to you upon your release by the jail. You have any questions as to the bond in this case, Mr. Winter?
To wrap this up, Jonathan James, WER's arraignment showcases the delicate balance of law, history, and human behavior in a courtroom. Despite today's misdemeanor charges, his criminal history and parole status heavily influenced judicial decisions. Bond, legal representation, and mental health considerations all intersect to determine the court's path. This case is a reminder: justice isn't just about today's charges. It's about patterns, risk, and procedure. If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping breakdowns. You won't want to miss the next courtroom drama.